On behalf of the Civil Rights Project, I'm very happy to welcome you to this webinar to talk about a very important issue that's confronting higher education across the United States. Since the Civil Rights Project was founded 17 years ago at Harvard University, the issue of affirmative action and college access have been central to our work. My assignment here is just to introduce the speakers and to set the stage. Basically, we've had an ongoing controversy over the legality and the proper conditions for affirmative action ever since it began in earnest voluntarily in the elite colleges of the United States in the middle 1960s and required in the 19 states that had separate colleges for black students and were required to desegregate under the Civil Rights Act. The Supreme Court first heard a case on this issue in 1978 in the decision in Bakke versus the University of California. In that case, the basic findings were racial quotas were illegal, that race could only be considered as one of a number of factors in admissions decisions, and that the principal justification for affirmative action was the compelling interest of universities in the educational value of diversity, which was based in part on findings of a faculty committee at Harvard University about their admissions. There wasn't another case before the Supreme Court for 25 years. In that case, Grutter versus Bollinger, there was an enormous mobilization of research and efforts across the United States, and there was a 5-4 decision that upheld the Bakke case, that sustained the possibility of affirmative action, that limited it so that it just couldn't be done by the numbers as was done in the undergraduate college at Michigan, and expanded the justifications to include the country's need for diverse leadership and the future of American democracy. The decision in Grutter provided significant deference to universities in making these decisions. That was challenged in the case that came before the Supreme Court from the University of Texas, Fisher versus the University of Texas. And that decision, the argument in that decision, focused on many issues, but particularly on the issue of whether or not there was an alternative. The decision in Fisher we will be discussing, and we'll be talking about what it means for colleges and what colleges need to do about it.
They would have told you.
The stakes of this issue are very high because the United States, since the time of Brown, has changed from a country where about 1/8 of the students were minority in our public schools to a country where about half are. There's tremendous inequality still in access to higher education, particularly elite colleges. Black students have only 1/5 the chance of white students to be in a selective university, Latino students 1/3. Now, almost all of the good jobs in the society depend on post-secondary education, and we're falling behind our competitors across the world. The stakes are very high. To start this discussion, I'm going to turn it over to our distinguished colleague, the Dean of Law at UCLA, Rachel Moran, who's a leading authority in this area. Rachel?
Well, thank you, Gary. That was extremely helpful in introducing the key issues in the Fisher case and the court's findings, as well as preparing us for the growing importance of social science research. Now, at the time that the Fisher case was pending before the United States Supreme Court, there was widespread speculation that the court might overturn Grutter, and everyone assumed that the case would be very close. In fact, the court upheld affirmative action. It did not overturn Grutter, and it was not even a close case. 7 justices joined the majority. Justice Ginsburg dissented, and Justice Kagan recused herself. Now, as a result of the Fisher case and the fact that the traditional paradigm was upheld, affirmative action programs are still subject to strict scrutiny. And that means that a public college or university has to show that the program is justified by a compelling interest, and then it has to establish that the program is necessary, that is, narrowly tailored to achieve that interest. Now, that means that it's going to be very important to understand what counts as a compelling interest. Gary mentioned diversity, which was made famous by the Bakke decision. This is a very inward-looking rationale. It focuses on the learning experience at the college or university itself, and it's not limited to race. So, for example, in Bakke, the court mentioned geographic diversity. If students from rural areas were underrepresented, for example, a college or university might consider that in its admissions. Now, in the Fisher case, the court also identified two other compelling interests which seem to relate to the kinds of interests that have been identified in voluntary integration plans in elementary and secondary public schools. These two are avoiding racial isolation and countering racial stereotypes. And you'll notice that in contrast to the diversity rationale, these are very explicitly focused on race. Now, in a public school system, you might be able to measure racial isolation by looking at the patterns of enrollment across schools. But obviously at a campus, that won't be as helpful a measure of isolation. So you might look at segregation in classrooms, in extracurricular activities, study groups, social settings, residential facilities. Countering racial stereotypes, as I mentioned, is not the same as promoting the diverse exchange of ideas. This is really about minimizing misperceptions and misunderstandings through interracial contact. The fourth compelling interest, which is developing inclusive leadership, comes out of the Grutter case. Interestingly, Fisher didn't mention this rationale, but since Grutter remains good law, we need to presume that leadership for a democracy, one that includes people from all walks of life, is still a compelling interest. And this might be demonstrated, for example, by showing that people from different racial or ethnic backgrounds are assuming positions of leadership on campus, in student government, in student organizations, and other venues. Now, the next issue is what constitutes narrow tailoring. Assume that a college or university has identified the compelling interests it wants to advance. To show that the use of affirmative action is narrowly tailored, first, the college or university has to show that race-neutral alternatives will not work in achieving those objectives. And then secondly, the college or university has to demonstrate that its use of race is working in achieving those objectives. Now, the real takeaway from the Fisher case, I think, is that the court is not going to be as deferential as it used to be in looking at whether or not a program is narrowly tailored. And the key quote here from the opinion is, "Strict scrutiny must not be strict in theory, but feeble in fact." So that means that you're going to have to think about the kind of evidence you need to generate in order to justify the use of race in admissions with a level of care and attention that will be, I think, at a new level. So let me just start by looking at how you might establish that race-neutral alternatives will not work. The first thing to bear in mind is this is not a strictly numerical inquiry. And I think Fisher tells us that itself. The University of Texas at Austin really had a unique situation. It had used a form of holistic review that considered race until 1996, when the Fifth Circuit Court of Appeals decided Hopwood versus Texas. Hopwood said that affirmative action was unconstitutional, and the United States Supreme Court did not immediately take that decision up for review. So after 1996, the University of Texas used race-neutral holistic review coupled with the legislatively mandated 10% plan. What's interesting is that before 1996, with race-conscious holistic review, there were 4.1% African Americans on the campus. With the race-neutral paradigm, there were 4.5% African Americans, a slight increase. Before, under the pre-Hopwood regime, there were 14.5% Latinos. Afterwards, with the race-neutral approach, there were 16.9% Latinos. Again, a slight increase. So if we could evaluate the efficacy of race-neutral alternatives based on numbers alone, it would seem that Fisher would be over right now, but it's not. Because you need to show not just a meaningful number, but also that your goals are being achieved. And so in the University of Texas case, the university showed, first of all, through a survey, that students still felt there were problems with racial climate on campus, and in addition they showed low enrollments of blacks and Latinos in seminar courses where the robust exchange of ideas was most likely to take place. The other things that I wanted to mention are that the analysis of whether race-neutral alternatives will work has to be sensitive to the mission, the identity, the fundamental character of the college or university. So in the Michigan case, the court rejected the idea that a lottery could be used to achieve diversity. It might achieve diversity, but it would undermine the University of Michigan's status as a selective institution. And you didn't have to sacrifice that to achieve racial and ethnic diversity. As I mentioned, the analysis has to be rooted in the compelling interest that the school has invoked. For instance, diversity on campus, and here the University of Texas looked at the seminar enrollments. And finally, the analysis has to be current. You're going to have to show on an ongoing basis the need for race in admissions, because obsolete data will not satisfy the searching level of scrutiny. Now let me conclude by briefly touching on how a college or university can show, assuming that race-neutral alternatives are not effective, that its use of race is working to achieve its goals. Catherine will be saying more about this in a moment, but I wanted to highlight that general studies on the benefits of affirmative action can provide useful context. They can tell us what sort of benefits to measure. They can also help us to instrumentalize those benefits so that we can measure them in an appropriate way. But general studies will not suffice. I think Fisher makes clear that you have to have specific data on the particular benefits of affirmative action to your own school's program. And I know Catherine will be saying in a moment more about what that sort of data might look like. All of the benefits have to be rooted in the compelling interests that you've invoked. If it's diversity, the exchange of ideas, how is that being advanced? If it's racial isolation, how is that being mitigated? If it's countering racial stereotypes, how are those being overcome? If it's leadership, how is your program actually promoting leadership for people from all walks of life? And again, that analysis has to be kept current to show the ongoing benefits. I do want to say one word about critical mass. In showing that critical mass is being achieved through your use of race, I again think that numbers alone will not be the whole story. You will have to instead look at whether or not your program is actually achieving the benefits that you want. And in doing so, consequently, you can conclude that critical mass is present in the student body. Now I'm going to turn it over to Jim, who's going to say a few words about some guidelines that the Obama administration has issued, as well as providing further advice to University Council.
Thanks very much, Rachel. And thanks to Gary for inviting me to participate in this. I just want to start by talking a little bit about the guidance from the Department of Justice and the Department of Education. And the basic point is that the guidance is accurate, but I don't know if it goes far enough to be helpful in terms of instructing general counsel at universities and colleges on exactly what to do. And I think Rachel did a fantastic job in explaining that, more so than the guidance does. The guidance is correct that institutions of higher education can continue to take steps to achieve a diverse student body, and that Fisher didn't change the standard of strict scrutiny that's used to assess affirmative action programs. What the guidance doesn't emphasize quite as much as it ought to, I think, is the fact that although the standard hasn't changed, the degree of deference with respect to narrow tailoring has changed. And the court made it clear that simply good faith efforts to achieve narrow tailoring are not enough. And the key phrase which Rachel emphasized is this idea that colleges and universities are going to have to show that there are no workable race-neutral alternatives. So that is to say, they're going to have to demonstrate that there are no race-neutral alternatives that would produce the educational benefits of diversity. Now that leads to the topic of how to advise college presidents. And I think what I would tell them is to listen to what Rachel just said about the decision. Another way to think about this is the idea that colleges and universities have to show that race-neutral alternatives are not workable depends an awful lot on what workable means. And that is not entirely clear from the court's decision, which in some respects is frustrating, but I think in some respects offers a silver lining. It's frustrating because in order to demonstrate that race-neutral alternatives are not workable, you need really to understand what the court means by workable. And here are some things that it probably can't mean. It can't mean that the race-neutral program will produce exactly the same student body, and if it doesn't produce the same student body, then it's not workable. That would be one extreme. The other extreme that also has to be rejected is that a workable race-neutral alternative is some alternative that produces some educational benefit. And I don't think that it's at that extreme either. So that means it's somewhere in the middle, but how exactly to define workable is left to the imagination of colleges and universities. And so what I think that means is that a college and university needs to identify, as Rachel was describing, the goals of the affirmative action program that they've adopted, that is, their desired results, have some way of assessing whether those results are being reached, and then have an explanation as to why race-neutral alternatives won't produce the same benefits without also imposing some costs. That is to say, as you might imagine, any use of an alternative to race is likely to result in a different student body. That is, it's likely to result in some trade-offs. And some of those trade-offs might have costs in terms of a university's overall goals. And I think the burden on colleges and universities is to be able to explain the point of the affirmative action program, the goals that the affirmative action program has set forth, some indication that those goals are being met, and an explanation as to why race-neutral alternatives not only will fail to achieve those goals as effectively, but might impose other costs. And the reason why I think the fact that the court didn't define workable could be a silver lining is that I don't think courts are in a very good position to assess those trade-offs. I don't think they're in as good a position as a university to assess those trade-offs. So I think the real burden on a university or a college is to really demonstrate to a court that they've thought this through, that they have a thoughtful, reasonable program, and that their use of race is consistent with the legal standards that the court has set out, and that the alternatives really aren't as effective. And if a college and a university can do that, I think they'll satisfy Fisher. And along the way, having a review of their own affirmative action program and being able to articulate the goals and articulate why race-neutral alternatives won't suffice might in and of itself be a useful exercise. So I'll stop there and turn it over to Catherine.
Thanks, Dean Ryan. As Dean Moran described earlier, Justice Kennedy's majority opinion in Fisher reminded universities of the importance of ongoing and rigorous research to the legal and broader discussions of both compelling interest and narrow tailoring. In concluding these presentations, then, I want to describe, in short summary, some of the relevant social science that has been presented and work that remains to be done. Specifically, I want to briefly synthesize what we've learned from research on the benefits of diversity as a compelling interest, as well as on percent plans, one of the most widely touted race-neutral alternatives. I'll conclude with a few suggestions for a research agenda moving forward. In considering the empirically identified benefits of diversity, we necessarily begin with Pat Guerin's groundbreaking research that identifies 3 types of diversity experiences students may have on a university campus. Structural diversity refers simply to the composition of student population and serves as a necessary antecedent to other types of encounters. Informal interactional diversity involves the opportunity to interact with diverse peers with a focus on frequency and quality of interactions. Most of these occur outside the classroom and involve activities such as participation in social groups. The last form of diversity experience, classroom diversity, refers to the incorporation of content knowledge about diverse groups and the opportunities to interact with diverse peers both in the classroom and through the curriculum. This work intersects and importantly expands related foundational research by scholars such as Tinto, Aston, Pasquarella, and Terenzini, who also sought to conceptualize the multiple influences on college student access and outcomes of interest. In describing what the empirical work has concluded, I draw from the Organization of the American Educational Research Association's amicus brief to the Supreme Court on behalf of the University of Texas to synthesize the benefits of diversity research. First, diversity promotes understanding and reduces prejudice. Pettigrew and Trott's 2006 meta-analysis, for example, analyzed over 500 studies from a variety of educational, workplace, and informal settings, including college campuses, and reached the overarching conclusion that positive intergroup contact reduces prejudice, and that greater intergroup contact is associated with increasing or decreasingly lower levels of prejudice. Diversity also leads to educational benefits such as improvements in cognitive abilities, critical thinking, and self-confidence, as well as promoting civic engagement and skills needed for professional development and leadership. Silvia Hurtado, for example, in a 2005 longitudinal study of over 4,400 students at 9 public universities, concluded that student interactions with diverse peers contributed in positive ways to student education. Among those positive effects were improvements in analytical problem solving and complex thinking skills, as well as an enhancement of sociocognitive skills and democratic sensibilities. Finally, empirical work has identified that diversity leads to improved classroom environments. DEA's 2012 ethnographic study, for example, found that University of Michigan law students strongly believed that increases in diversity led to improved learning in the classroom setting. As you heard from Deans Ryan and Moran, in consideration of the compelling governmental interest of the benefits of diversity, social science has also demonstrated the harms associated with tokenism, racial isolation, and stereotyping. Within that body of research, scholars suggest that the determination of critical mass needed to avoid harms must ultimately take into account the university's evaluation of the educational benefits that it seeks, as well as the context in which those benefits are sought. Social science has also provided a robust understanding of the strengths and challenges that percent plans, the most typically touted race-neutral alternatives, present. As a reminder, percent plans are automatic admissions policies that provide varied college entry guarantees in the 3 states in which they are currently being implemented. In Texas, for example, percent plan eligible students may choose to attend the public institution of their choice. A large number of studies have sought to understand percent plan impact on access, and have generally centered on either changes in representation at the application stage or at the admissions and enrollment phases. In synthesizing this work, again, several consistent findings emerged. First, as Lloyd, Light, and Sullivan and others have found, the eligibility signaling through the plan itself, as well as through related and aggressive outreach and recruitment efforts, have had a positive effect of increasing aspirations of traditionally underrepresented students. Similarly, Domina in 2007 also found that the percent plan in Texas, alongside specific and related university scholarship programs, functioned as a K-16 reform mechanism as well. But importantly, policy signaling has had a more tempered direct impact on application patterns, particularly for underrepresented students. Lines and Tienda, for example, found that in Texas, the number and shares of represented high schools by geography among the University of Texas at Austin applications increased as a result of the percent plan, but similar outcomes were not seen at the state's second flagship, Texas A&M University. Conditional on application, many studies have also sought to understand percent plan policy contributions to admission and enrollment decisions. Several studies have found that at a subset of flagship campuses, not only did the percent plan increase representation of students from high poverty schools and schools with greater shares of minority students, but also that the longevity of descending power of high schools increased. But, as Horn and Flores found, there are racial and ethnic differences as well as there are racial and ethnic disparities even among equally qualified percent plan students in the consideration of selectivity among the first choice college preferences. In short summary then, although varied in scope and rigor, the majority of findings related to racial and ethnic representation among admitted and enrolled students through the percent plan indicate that such plans alone have not contributed substantially to campus and classroom diversity. In considering work that remains to be done with respect to understanding the compelling interest and narrow tailoring of race-conscious admissions, universities might begin with a set of broad considerations. Research needs to continue to examine patterns of access and exclusion complexly through the consideration at different stages and contexts. Our equity research often focuses on the bookends of policy, admissions, and exit, but needs to be more multi-leveled and longitudinal. Additional research is also needed to assess the longitudinal impact on social mobility and engagement of expanded access and success mechanisms. Such work might consider contributions to the labor market or moderation of intergenerational poverty, for example. And while challenging, institutional research needs to increasingly seize opportunities to implement studies that seek causal understanding. In conclusion, then, I encourage universities to leverage current and ongoing efforts, particularly with regard to data collection at the state and national level, as well as to consider the formation of multi-stakeholder partnerships to take on these tasks. Organizations like the Civil Rights Project, Marta Tienda's Texas Higher Education Opportunity Project, and others serve as strong examples of the ways in which scholars, state officials, and university leaders can work together to produce rigorous assessment useful in improving institutional decision-making. I think we are now opening the floor up for questions.
If you'd like to submit a question, just type it into the chat bar.
While we're waiting for the questions to come in, I want to ask a first question to our speakers, which is, how can we get the lawyers, the institutional researchers, and the faculty members of universities to contribute to the process of reviewing their plan and showing that it's necessary in the context of the university and the student population that it serves? What would be a good way to do that? Normally, these different parts of the university don't speak to each other very effectively.
Well, I'll just begin by saying that I think that this is a challenge of leadership. After each of the prior cases involving affirmative action, I think there was immediately in the wake of those decisions a call for more research, which really did not materialize in a significant way. Fisher is a clarion call, not just for general research, but for research specific to the campus. I think foundations can play a role in convening groups that can help to set up best practices in this area, as well as a research agenda. Then I think that networking will be important, that colleges, particularly the most elite public colleges and universities around the country, who can still practice affirmative action. Here in California, we're already banned from doing so by popular initiative. Those colleges and universities must come together as a consortium to figure out how to share some of the costs of keeping research up to date by establishing instruments that might be universally useful to them and then could be tweaked for particular circumstances. So I think foundation leadership, university leadership, I believe the government, as Jim said, could do a better job of providing guidance and best practices. All three of those things will be vital.
I would just add to Rachel's point that building on the assets that a variety of stakeholders within and between institutions bring to the table is essential. We have a limited resource circumstance across all universities in the United States, and being able to leverage the skills of scholars who are addressing these issues, of leaders, as Dean Moran points out, who have investment in furthering the mission of their own institutions, and the other private and public stakeholders who bring important perspectives to bear, I think is essential.
This is Jim Ryan. The only thing I would add to that is to agree with you, Gary, that it's awfully hard sometimes to get different parts of the university to speak with one another. But I think it's crucial here, and I think Rachel's right, that it depends a lot on leadership. And I would just emphasize the real importance in this context of having lawyers and education researchers and social scientists talking to one another so that the research agenda is formed together. Just to give you an example, this is not to say that exploring the issue of whether diversity has educational benefits is uninteresting. It's an incredibly interesting topic, and it's one that deserves more research. But the court has more or less accepted in Fisher that diversity is a compelling interest, and I don't think that needs to be established. So if you're talking about an institution with limited resources, I would think the focus, at least in the first instance, would be on establishing open questions, such as, why would a particular race-neutral alternative not be workable? And I think it's conversations between lawyers and researchers that will get the resources focused on the legal issues that are the most pressing and the most difficult and need the most shoring up. And again, it's not to say that research around these other issues is unimportant, but if you're focused on how do you develop and then defend the most effective affirmative action plan, I think a conversation between lawyers and researchers would be crucial to that.
I'd just like to add one positive note to this discussion, because it sounds like an enormously challenging job. I think that there are a couple of things that people need to understand. Federal judges don't want to take over universities. I've worked with a number of federal judges as an expert witness and special master. They don't even want to take over school districts, to say nothing of universities. So they will hope that there's an answer to the problem. The second thing is, there are a lot of people on every campus who could contribute to this, and our experience in the Civil Rights Project is if they're asked, many researchers are willing to take this on. They just have to be asked, and oftentimes the researchers don't understand what the legal issues are exactly, so those have to be explained. But there are rich resources on many campuses, and there are courts who will respect and be interested in hearing from universities. So we shouldn't be overwhelmed with this task. But we do have some questions from outside. Natasha?
Sure. Our first question is from the Regional Council from MALDEF. On remand, Fisher has argued that UT must establish its compelling interest through a strong basis in evidence, and that simple deference to UT's judgment is not acceptable. Is this conceivable, and if so, would this present another obstacle to institutions?
I'll start again. First of all, on remand, I think the big battle that's going on is whether or not this is going to go back to the district court for more production of evidence, or whether it's going to be decided at the Fifth Circuit on the existing trial record. That's a very critical debate, because Texas wants to say, we produced evidence to support our program based on our understanding of what narrow tailoring requires. Now the Fisher case tells us the scrutiny is going to be stricter than it used to be, more searching with respect to narrow tailoring. So we would like the chance to offer more evidence that our programs are narrowly tailored to achieve our objective. And the plaintiff, Abigail Fisher, would like to rest on the existing record. So I think that's the real issue to watch at the moment. Is this going to go back to the trial court? And if it does, what sort of additional evidence might Texas offer on these issues? And then, of course, whether it will be sufficient. But certainly the scrutiny will be tougher, and certainly the court is going to demand more in the way of evidence. And that is why I think it's so critical that we find ways to work with counsel and researchers to produce the necessary information about the particular campus's program and how it is affecting whatever the interests are that have been identified, whether diversity, countering stereotypes, reducing racial isolation, or promoting inclusive leadership.
Next question.
Our next question, Dr. Horn mentioned focus beyond access. What constraints, if any, exist with regard to the use of race in developing retention programs?
Attorneys, do you want to answer?
Well, I think one question with retention programs would be, are there workable race-neutral alternatives that achieve your objective? Obviously, it's not enough to bring in a diverse class. You need to keep that class. And so when you do retention programs, you have to show that race-neutral alternatives aren't viable ways to achieve the objective of retaining the diversity in your student body. So for instance, if you could use grade point average as the basis for retention programs, and that would achieve your objective and it's race neutral, I think you would have to consider that, because the concerns about race in decision making transcend admissions. Any use of race in government decision makings will be subject to strict scrutiny. So I would assume that you would want to make out the case that you can't use some other mechanisms like class standing and grade point average.
I would agree with that. I mean, this question hasn't been as fully litigated as the admissions question, but Rachel's exactly right that the general standard regarding the use of race by governments in decision making is strict scrutiny, which means it has to be narrowly tailored to achieve a compelling interest. I agree that it would most likely count as a compelling interest to retain students who have been admitted. So then the question would be, is the program sufficiently narrowly tailored, which in turn would raise the issue of, are there available race-neutral alternatives? So I think the smartest course would be, are there alternatives to the specific focus on race to help not just minority students, but all students who are struggling?
Now, would either of you think that there'd be any problem of a campus offering a Latino-themed or American Indian-themed or African American-themed support program, so long as it wasn't closed to other students who were from other racial groups who might be interested?
In fact, I think that would be fine, because what the court has emphasized is the use of race in the individual treatment of students. So when you treat individual students differentially based on their race, that is a problem. On the other hand, when you promote, for instance, African American studies as a means of promoting engagement and interest, so long as that's open to all students, the promotion of a particular kind of ideas which happen to have a racial or ethnic, component is fine. I mean, you can have African American studies programs, Latino studies, Asian American studies, because that is promoting the diverse exchange of ideas. Even if it's racially and ethnically themed, it's not treating students differentially based on race or ethnicity, so long as all students can participate in those programs based on their interest in those issues.
Yeah, I think Rachel's exactly right. I mean, the one thing that Justice Kennedy really dislikes, and he has the most important vote on these cases, the 7-to-1 outcome here was a bit of an anomaly, but he really is the swing vote in most of these cases. And as Rachel was indicating, he is really averse to classifying individuals on the basis of race. And so in Fisher and in the parents involved case, which was the K-12 voluntary integration case, he has been constantly urging that governments explore all possible alternatives to the individual classification on the basis of race, while at the same time making it fairly clear that if a program involves race or ethnicity but doesn't involve classifying an individual, that he has much fewer problems with that. So I completely agree with Rachel.
Next question.
Our next question comes from Excellencia in Education. How far does an institution need to go to show that they have attempted the race-neutral approaches? Is it exhaustive? If so, how does the institution balance exhausting a race-neutral approach with the cost of implementing these approaches before moving on to the race-conscious option?
I'll take a stab at this. I think that's just a great question. And again, it gets back to the issue of the court not defining what counts as workable. And I think as a practical matter, and this picks up on Gary's point, and it's a point I made as well, that courts are likely to be reluctant to take over universities or colleges' admissions programs. And so they're going to want a sense that the college or university is acted in a thoughtful and thorough manner. And so I think what it means is there has to be some assessment, some real assessment of some plausible race-neutral alternatives. And if there are real costs to those alternatives or real questions about their effectiveness, I think that would be enough to show that they're not workable. Now, I have to underscore that there's a little bit of uncertainty there just because, like I said, it's not entirely clear what the court means by workable. But I think if you could show that adopting a race-neutral alternative, for example, would seriously compromise other values of the university, whether in terms of academic standards or some other goal that is thought important, that's sufficient to demonstrate that the alternative is not workable. The court did indicate in Fisher that costs do factor into the equation. So I think some effort to demonstrate that those plausible alternatives have been considered and an effective and persuasive explanation as to why they're not really plausible or they're too costly ought to suffice.
The only
Kathy,
thing,
I wonder if Kathy could add, because she didn't have a chance to talk about the fact that percent plans, for example, have been tried and failed in many places, and there are logical reasons why they can't work in different settings. Do you want to talk about that a little bit, Catherine?
Sure. So I think that in further demonstrating the utility or absence thereof of race-neutral alternatives, beyond the importance or an extension of the importance that both Deans Moran and Ryan have noted of the context-specific or the campus-specific work to study the implications of these various approaches. I think we can also draw from, and correct me if I'm wrong, attorneys, but I think there's also still space to draw from a depth of research that's been created that is relevant to the same kinds of approaches in a variety of contexts. So the percent plan, as an example, has a broad and deep set of studies that have been undertaken in the 3 states that have attempted to use a variety of percent plan alternatives as an admissions strategy. And what we've seen consistently across 3 relatively different contexts in California, Florida, and Texas as the initiator of this kind of plan is that consistently the same challenges to the plan arise even across contexts. So it seems that there's also, I think, space to draw from a broader literature and to Rachel's point of earlier, draw across a set of resources that may be looking at the same kinds of questions to make decisions about what may work on a specific campus.
And I would just like to add that I think that the Fisher case is unique, that the plaintiffs targeted the University of Texas because it had, due to the Hopwood case, had a long experience with a race-neutral paradigm. And because the numbers were comparable before that paradigm was adopted and afterwards. And therefore, I think that the feeling was if we're going to show that race-neutral alternatives can work constitutionally, this is the place to take that stand. Now, the fact that this has been remanded for further addressing of that issue suggests, as I said, it's not a numerical inquiry. So even in this scenario, they haven't been automatically successful. Most schools have not attempted a race-neutral alternative. Michigan had not. So what you have to do is figure out what are the viable alternatives and then do your projections. So you might look at what a 10% plan would yield if you looked at public high school students and private high school students in the state of Michigan. And you might see that that changes not just your numbers in terms of diversity, but also the national character of your institution. you might take a look at a lottery and say, you know, given our current applicant pool, it would have these consequences, but once it's publicly announced, it's going to vastly change the people who apply, because suddenly people who never thought they could get in are going to put in an application for the lottery. The third thing that I think you can take a look at is what a race-neutral holistic review might yield, considering your current applicant pool. And finally, and I think this is important, there are schools like the University of California which by political mandate have been banned from using race in admissions. And they filed an amicus brief on the consequences that has had. And I think you can look to experiences of schools like those, which are comparable to your own institution, to make some educated guesses about what the impact might be on your school.
So in terms of thinking about what we do from here on out, I think one of the things that we need to make sure that happens is that there's be a rich communication within higher education about these issues. We have the email for the people who signed on to this webinar, and we will communicate with you about whether you want to be on a listserv that goes on to discuss these issues more specifically. We also are working with the Educational Testing Service, and we've commissioned a series of studies on research on the major alternatives to affirmative action, which will be published in the not distant future. A lot more research of this sort needs to be done. So we hope that this session is a beginning rather than a freestanding and ending opportunity, and that we will be able to communicate with each other as this issue unfolds and as research accumulates. We'd like to thank very much Professor Horn, Dean Ryan, and Dean Moran for participating today, and to know that you will be continuing to hear from us at the Civil Rights Project and from other organizations that are working on these issues. Thank you very much.